And first let me give my thank yous to individuals who made this possible. In addition to Dan and Billy Alban, Norma Horwich, who greeted me last night at about 9:30 at night, having waited for me to work my way through the dark from Pennsylvania. And then many of you who've written and sent me emailed questions over the last month so that I would have a few extra topics to address today. And as Dan pointed out, somehow I just hadn't been to Connecticut in this work that I've done with continuing care communities until today. So now I'm adding Connecticut to my list. Let me start just a little bit about how I got to this point. I went to Pennsylvania from New Mexico. I had been a practicing lawyer for 15 years in New Mexico and had been teaching off and on. And came to Pennsylvania, then it was just called the Dickinson School of Law, and started working with our family law clinic at the law school, where students represented families on the traditional types of issues, usually divorce, custody, child support. And I was asked to think about whether or not we needed another clinic, and I said, just looking around in central Pennsylvania, what about elder law? And so slowly we worked forward on that, and we opened the clinic in 1990, 11 years ago. So it was a number of years ago. And so when we ran the clinic, our mission was to represent older adults, and we had a grant under the Older Americans Act, and that's how we got started funding-wise, and it took off. We never advertised. We always had plenty of clients who just found us by word of mouth. One of the groups that came to me in 2005, 2006 was a group of residents at a CCRC. Now at that point, I knew nothing about CCRCs. And the residents group came and met with me. They talked to me a few times by phone, and finally they came and insisted they meet with me and said, here is what's going on. We're in a continuing care retirement community in Pennsylvania, and the management is planning to double in size on the same footprint that we're on right now. That means essentially we're going to be living in construction zone for the rest of our lives. And that would be okay, but we really have some people in our group, one of whom is a financial analyst, and he doesn't think our location in Pennsylvania can support a doubling in size. And so we think we're getting in over our head, and that's going to create debt for the existing residents that we may not be able to support. And we'd like to do something about it. And I said, well, why me? And they said, well, because we've been to the regulator of the state, and he won't do anything. We met with him, and he said it's not his job to consider this kind of an issue. And so I said, okay, well, interesting. And so that's when I started digging in and looking at Pennsylvania's law on continuing care associations, residences. And I decided to take my own trip down to the state regulator's department, and I made an appointment, and he wasn't there the day I came. And so I decided I would go back again, and this time I learned by then reading the law that every CCRC in Pennsylvania files an annual report. I thought, well, I'll go and look at their annual reports and see what that all amounts to. That would be a convenient place to go and do it. So I made another appointment, and it's public record, so I was allowed to see it. And so I went there, and they looked at me when I arrived like, why are you here? And I explained I had this appointment, I was coming to see the annual reports, and they looked at me like, well, what are you talking about? So I kind of sat there and said, I'm insisting that I'm going to see the annual reports. And so I can't remember if I had to come back a third time or not, but anyway, I did get to the reports, and they rolled them out to me on a trolley, and they were all neatly stacked, and I realized that they had never been read. So annual reports were filed with the state, but nobody had ever broken the seal on the reports. And so I was the first person to have that joy of reading the reports. And at the end of the time, I said, well, why is it that the state doesn't do anything with these. And so I talked to the state regulators, who all were very nice people, by the way, and different people within the organization, and they really led me to this, realization that Pennsylvania's law is a, quote, disclosure law, and that that's the usual model. And that a disclosure law is not a content regulator law in their viewpoint. It is a law that says, whatever you are as a CCRC, and we're going to say that if you provide care by contract for more than a year, and you promise continuing care, you are a CCRC that must register or be licensed in our state. You must do certain things in terms of disclosures, and you must report to us that you have done those things. And if you do that, that's what we do as the regulator. And so I said, well, what happens if an institution gets in trouble? And they said, well, that just doesn't happen. And I said, okay, that's interesting. And I was naive back then. So I wrote a little short article summarizing the law and saying, it could be, and by this time I'd done enough research to know the history of CCRCs and that there had been great successes and occasional failures. And so I wrote this little article, and in it I said, it might be really time to take a second look at Pennsylvania's law, and more importantly, to determine whether or not, at a minimum, they could share the information they're collecting in some data form, so that you have a little bit of comparable information about what, that somebody else could use to decide whether or not this contributes to success or lack of success. And I said, and one of the things that's not clear to me is whether Pennsylvania's been lucky or Pennsylvania's well regulated. I'm not sure which is true. Well, that was 2006. The article came out, and I got my first telephone call from the superintendent of insurance in charge of CCRCs, and he was not happy with me. And his first question to me was, why didn't you interview me before you wrote this article? I said, well, frankly, because I didn't know that you existed. And I said, when I talked to line people, in your department, nobody ever suggested I should be talking to you. I would have been happy to talk to you. In fact, let's make an appointment, and I'll talk to you now. That was the last time I talked to him for a while. But basically his message to me was that Pennsylvania is doing a great job of regulating CCRCs. And he said, because there's never been a bankruptcy. That was his message in Pennsylvania. So, okay, well, that's an interesting standard. And so you go along for another couple of years, and of course we had a bankruptcy. And we had one that's rather high profile, Covenant Hills in the Pittsburgh area. And then we had the bankruptcy filing of the Erickson chain, and the Erickson chain had several CCRCs in Pennsylvania. So I thought, well, maybe it's time to rewrite that article and ask again the question of, are we lucky or are we well regulated? And this time I did call up the superintendent of insurance, who was the contact person, and asked him to provide his viewpoints on this. And he was very nice, as all of the state employees have been. And he took the position that because they never had residents forced to move out of the facilities, that they had never had a lack of success in Pennsylvania. So we'd shifted the standard. It was no longer no bankruptcies. It was that nobody had had to abandon their home. And so that was the point at which I said, okay, we're probably lucky. And then as the financial crisis that started in 2008 deepened, I was contacted by Congress and contacted by the General Accounting Office to participate in a survey, study, investigation that was really driven in large part by the Erickson bankruptcy, because that frightened people when an organization of that magnitude went into bankruptcy. And fortunately, they emerged. And fortunately, they emerged right before the report went to Congress from the Government Accountability Office, the GAO. GAO basically said, the title of the report says it all, something like great places, but not without risk. And they did not recommend federal regulation of any sort. And I understand why. Because in a time period in 2008, 2010, where you have huge issues with banks, financial institutions, war, huge healthcare issues generally in terms of accountability, the CCRC industry is kind of small, right? And so there's not a willingness to take that on as a federal regulatory priority. And so as we were getting ready to go for the presentation of the report to the Senate committee, across the hall from us where we were doing our presentation was a committee that was on financial regulation industry, financial services industries that in 2010 were just in turmoil. And so I knew that their major attention was going to be over there. So I made the decision to call for a National Bill of Rights for residents. My thinking on this is rather simple, is that fine, if a agency does not have the financial ability to have, or we don't have the ability to afford another federal regulatory agency, and if we don't want to get terribly involved in, a federal standards, you nonetheless could enable residents to police their own organizations on at least a threshold level. And so my theory was that similar to the National Bill of Rights that is in the Nursing Home Reform Act that came out in 1985, you could have a National Bill of Rights that permits residents to do their own enforcement, gives them some power to do their own enforcement of a basic set of standards. And the template for that is the Nursing Home Bill of Rights in the Omnibus Bill of 1985. Continuing on from there, I've recognized that even getting a National Bill of Rights passed is tough. Again, Congress is distracted with other problems, and perhaps they are more important problems. But what's been important in my experience since 2010 is that residents in the states have taken this idea forward, and many states are now coming forward with their own state resident Bill of Rights. Some states have a template for a Bill of Rights within their state legislation. Pennsylvania does, for example. Oregon does, and they recently amended their state law to give residents greater rights. New Jersey does as well. So several states have templates. But beyond those kind of basic rights, which are almost always disclosure, right to certain disclosures, the question is what more should there be? In the last year, what I've focused on increasingly is not just the ability to get financial information on an annual basis, but to get financial information that is understandable. And the financial information, often what that requires is comparable information. And so many states, including Connecticut, does a great job with their consumer handbooks, but it would really be great if we could provide better comparable information so that residents can see, okay, this institution over here, which is quite different than our institution, they're spending X on food services. How does that compare to us? So at least people can have a sense of where the dollars and cents comparable information might be. And a second thing that I have realized is that there needs to be an effective voice for residents within organizations. And I think one of the most important ways to achieve that is through the right to be on governing boards of your CCRC. Resident members on governing boards. That's probably one of the more controversial things I've managed to say over time. The good news is that in New Jersey, for example, it's been the law for a number of years and it's worked quite well. There was tension at first. Residents and boards don't always get along, and the boards might have been a little bit suspicious of residents and vice versa. But what I hear when I talk to CCRC residents groups in New Jersey is that over time it has worked. And the more the time goes along, the more the boards recognize the value of having a resident member on their board. And I think New Jersey might even, I can't remember, New Jersey might even require 2. I know many boards do have 2 in New Jersey. And so that certainly it doesn't have to be a problem. And the vast majority of time, the interests of the board and the interests of the residents are exactly the same, right? To have a successful successful CCRC. So one of the first things that was asked of me is, well, what about conflict of interest? And 90% of the time, there's no conflict of interest at all. You're all moving in the same direction. And every board has to have a conflict of interest policy anyway. And so you have a policy where if the question was going to be, are we going to renovate Unit 5A, and 5A is the resident board members unit, that would be a conflict of interest if you're going to be, spending the, sums of money to do that. So the resident wouldn't vote on that particular issue. But that's a standard conflict of interest policy that every good board of directors should have. So resident rights, a key right, membership on governing boards. But as I've learned, that is more challenging than at first it appears. Let me tell you just a little bit about the story about Oregon and what's going on there right now. As you may recall, in my lengthy life story that Dan was so kind to share with you, I spent time in Oregon while I was on sabbatical in 2009. And while I was there, I had a great experience of being able to tour different types of long-term care facilities. And while I was there, I was actually working on my contributions to the General GAO's report on financial risks for CCRCs. So I was already in that mode, so I just started doing tours of CCRCs in California, actually, and Oregon. And while I was there, I did not hear about the problem, but after I left, somebody reached out to me and said, we've got this little issue going on here in Oregon. And the issue is really not with the board that runs the CCRC. The particular CCRC is called Rogue Valley Manor. It's a long-standing CCRC. It's 40 years old, as I recall. But 20 years ago, they stopped being a standalone CCRC, and through leadership decided to move out and have other continuing care retirement communities under an umbrella organization. So they created that umbrella organization called Pacific Retirement Services. And Pacific Retirement Service it's a nonprofit, both the CCRC and the parent organization. And Pacific Retirement Services is the sole member, I'm getting here into law, sorry about this, is the sole member, in essence, the parent company for Rogue Valley Manor as it was set up. So what the residents began to realize was, even though they had good interactions with their board of directors at Rogue Valley Manor, the decision-making power about finances was the next corporation up. And they felt they did not have good access or information about that organization. And so eventually, there was some serious questions about investments made using resources that they felt were Rogue Valley Manor's resources, real property, that was sold for purposes of developing for-profit investment entities. One was a golf course and one was a hotel. And at least the golf course was not terribly successful. So Rogue Valley Manor was supposed to be paid as a preferred stockholder in the country club, and they did not receive any payments. And in 2010, they were told to write that debt off. They were not happy with that plan. And so that's where they began to say, our board of directors at Rogue Valley Manor needs to protect us better. And the board frankly agreed. And so they turned to the next corporation up, Pacific, and said, we need to have better accountability for these financial decisions, or we need to break away. And Pacific did not take that seriously, and eventually it came to the point in August of this year where Rogue Valley Manor's board voted and proceeded to sue the parent corporation to, in essence, succeed from this parent-child relationship. That's extremely unusual in the world of long-term care. One of my colleagues who works on the management side of CCRCs, and who I have is a lawyer, and we have a good friendly relationship, even though some people think we're on opposite sides. When I told him what was going on, his email back to me was, wow, ... I mean, wow. And so that was pretty surprising. The court looked at the suit, and the complaint was not an outrageous complaint. It was kind of a mild complaint. It really just said that we aren't getting along, we'd like to separate. And didn't go into, thousands of details. And the court basically said, I've looked at the governing documents, you don't have the right to succeed. Your sole member is controlling you, and they can determine what's going on here and dismiss the suit. And the next day, the board was fired. And the very beloved chief administrative officer at Rogue Valley Manor was relieved of his duties as well. That hasn't stopped the concerns of the residents at the board, at Rogue Valley Manor. There's about 1,000 residents at the organization. Over 85% of them have voted to continue to try to either separate from Pacific Retirement Services or come to some better arrangement so that they feel more comfortable about financial decisions in the future. And they're asking for some financial accountability about the past. My message from that is that you can legislate, anything you want to. The real question is, can you get effective rights? And one of the, ultimate rights of a resident would be the right to demand accountability of an organization when they think it's right. Now, it can't be a frivolous demand. It can't be, this week I've decided that I want accountability about, how you spend money on flower arrangements. And so therefore it would need to be something where a significant percentage of residents agree that there needs to be accountability about that issue. And so if that is the next set of rights, I would say it's the right to have a cause of action, whether it's an administrative cause of action or a court cause of action, to seek enforcement of key accountability features. That is certainly the most controversial thing I could say to a management person. The idea of giving a cause of action to residents terrifies the average corporate board, not just CCRC boards, anybody else. And so, that's the ultimate weapon, if you will. If you can't get along, that residents could seek accountability, demand accountability through the court system. I can also say this, 99% of the time, you don't need that. Because any well-run CCRC, as all of you know from living in well-run CCRCs, is that CCRC management does listen to residents most of the time. And that's how they are successful. No one will go to a CCRC, the new residents, if there's even a hint that there isn't a pretty good relationship between the management and the existing residents. And existing residents can try to hide problems for a while, but if it becomes a serious problem, they can't hide it very far. And they don't want to hide it very far because they respect their fellow new residents. So it's the rare case where there would need to be that cause of action right. And that's why I say it would have to be a high percentage of residents who would agree to that if you're going to give the rights at all. Now, I also have to say that with rights become responsibilities. And what many people have moved to CCRCs for is they want financial accountability without responsibility, in the sense that their own responsibility. They know their responsibility is to pay their bill, but they don't necessarily want to have to spend time with oversight. And I respect that as well. So an organization that seeks the right of oversight is also going to have the consequences of responsibility for whether or not they use that oversight or that voice ability. And so that depends on having residents who are, like you all, very interested in being involved. And not every organization will feel that way. And so that's going to be an organization by organization decision, I think. I was recently with a group of friends and we were talking about CCRCs, and I was telling them one of my stories about some aspect of CCRCs. They said, oh, when we get to the right age, we're just going to join together in the neighborhood, we're going to get a couple of condos, and we'll just do this ourselves. And I said, well, guess what? You just described how CCRCs got started. You know, it was residents who decided that they wanted to join together and share their funding so that they could have a better way of dealing with aging and a more engaged way and share it. But then they recognized, well, we want to have this continue beyond our own lives, and so that's how the formal type of CCRCs began. And I also point out there's a difference between a co-op and a CCRC. In a co-op, you really do own your own, right of control, and you live or die by that right of control. Whereas in a corporate organization that runs your CCRC, the most you're ever going to have is a voice. But what you want is a voice that's heard. You're not going to have control of the organization. And most of you don't want control of the organization because then you also have the responsibilities of all the financial risk decision making. So I'll stop there. Is that Billy a good place to stop? Billy promised that she would keep me on track time-wise.